Mr. Simmons, you said just earlier that consumers will only do a limited amount of opt-ins when we were talking about that. And I'm curious about that, particularly because if they're standardized, like a lot of them are on a platform, I would think after you've done 10, you won't care if you do 30. So I'm just interested in the rationale behind that.
I mean, that's possible. But the other thing might happen is people might not want their information spread so widely.
And that
increases the risk of a breach.
So, and I think that's an important part, and I'm actually going to disregard the privacy part when I ask these questions, because that is one of, the flip side to sharing data is more people have my data.
Right, exactly.
And I think that is an area where we continue to go. Mr. Del Rahim, you gave a speech in Israel, and it discussed how not all data is alike. And I'm generally curious as to what types of data are more susceptible to being used in an anti-competitive manner. Because I think, like, from somebody like me who doesn't, understand this, which I think is most consumers, like, data is this one all-encompassing word, but it's very different, correct?
It is. It is very different. It takes many forms, and we have to take a look at that and its actual competitive impact. As we look at the GDPR regime that Mr. Sensenbrenner raised, in addition to what the Chairman Simon said, the other thing we look at is whether that regulatory regime actually creates barriers to new entry, is the cost of that collection, and whereas an incumbent may have already gathered certain data. But as I mentioned to Mr. Johnson, there's user data, there's usage data, and there's different qualities and attributes for each sets of data.
Okay. And then I'm going to actually let you continue talking about the Washington versus the franchise deal, because in a completely different sector, this is something we saw happen an incredible amount in North Dakota, which when our economy was growing, is small businesses having employees taken by larger businesses after they invested. I think one thing that, particularly with any specific skill set, is the first 3 months, 6 months to a year when you're training a highly skilled employee, the investment you're putting into them from a business perspective far outweighs the return you get. So you're relying on that employment to pay off in year 2, year 3, year 4. So, and I know 5 seconds wasn't enough, so I'm going to allow you some time to answer.
I was, the chairman was generous enough to allow me more than 5 seconds, which I did. But I think, you raised the point I think is really important, because we have to take a look at each of these restraints. Again, not a horizontal. We argued, we filed in the WAPTEC case in Pennsylvania. We filed in the Duke, North Carolina case, a number of these, where we have gone in aggressively saying that this should be per se illegal. However, when it is within the system like franchise, as I explained, the rule of reason should apply. Are these reasonable restraints? If you're saying that you can never leave for the next 6 years once I train you, well, I think a judge could find that unreasonable. However, there's limits, and there's a test that our Supreme Court has put down, and I would submit what we have submitted is well within what the laws and the precedents, legal precedents are.
And then would you expound on how that actually protects workers?
It absolutely protects workers, because it provides that small business owner the incentive to actually invest and train that employee. So the new employee who wants to enter the workforce can now get trained by that franchise owner, because for those first 6 weeks that they're learning how to do a tune-up or a break, or you don't want them to walk across the street to the other competitor. And so those within reason can be, and every case is different. Every franchise, every restraint should be treated differently. They should not be banned as per se illegal all the time, because some plaintiff's class has brought that case.
And then, so that's what you mean where the reasonableness test comes in?
There's a set of tests, in its duration, in its effect, and we look at those as do the courts. And there's a set of case law that guides the factors that go into analysis.
And then I guess this can be for either one of you, but I'll ask Mr. Simons. As we talk about data sharing and how this creates a competitive edge, I ignored it for 4 minutes and 30 seconds, but how do we factor that privacy concern into this conversation?
So you mean on the competition side?
Well, if somebody has my data and we're requiring them to share my data, that means 2 people have my data.
Right. So there's a trade-off. I mean, you just have to balance one against the other. If it's voluntary in terms of who shares, whether the consumer's data is shared or not, that leaves it up to the consumer.
So you're saying voluntary on the front end?
Yeah, I mean,
it has to be voluntary.
I mean, the consumer can make a judgment. Maybe there's an issue with how informed the consumer is, but the consumer can make a judgment about, do I want to be able to port all my data from one player to another, and now my data is in two places, and did I just double the risk of my data being breached?
But when they do that on the front end, right? I mean, on
Yes.
whatever service they're getting, they're going to do it. That's the first
Yes.
question they're going to get.
Right.
Thank you.
My time has expired. Now recognize Mr. Armstrong, the gentleman from South Dakota, for 5 minutes. Or still North Dakota.
There's been suggestions that companies with large data repositories be forced to share that data with smaller competitors, especially since data is non-rivalrous. That seems to me like an extreme intervention from the government. I'm going to just start with, do those proposals concern you?
Yeah, so it's non-rivalrous in the sense that you can duplicate it without diminishing the other, the initial copy. The problem is it may be expensive and costly to produce the data set in the first place. So one example of that we've had in our enforcement involves title plants. So that it's all publicly available, right? Because that's where, the title plants are collecting title information and then they're getting it from public sources, either online or they go to the courthouse and have to get it. So it's expensive, though, to create that title plant in the first place. And if you made the person who creates the title plant in the first place duplicate it for free, then what's the incentive to create it in the first place?
I agree with that. Look, that's not to say that somehow the laws would not allow us to force that. We have a high burden to meet should we want to force data sharing, but I agree with Chairman Simons that we should be very wary about doing that. Now, if there's a merger and you have two data sets and we look at those as assets and there's an overlap where they would have too much data, then that's one where we could say you must sell this off, one of the sets off before we allow the merger to go through. But as far as a company who has invested and gathered that data through investment and hard work, we should be very careful to not force that sharing upon them, as the Supreme Court has warned us in the past.
And again, I'm just prefacing this, that this is not even discussing the privacy part of that conversation, which is a whole different issue. And I think that's important in that when we talk about this, we always have to make sure that, again, that privacy is part of that conversation, because forcing somebody to sell their data or share their data is running into that as well.
Unless they acquired it illegally, then that's a whole different story.
Well, then we're talking criminal law, and then I could actually probably sound fairly smart about it. But so when dealing with artificial intelligence and machine learning, often the benefits of innovation and increase with larger data sets, that provides a benefit to consumers in a lot of instances, and we're going to continue to go down this road. How do we approach large collection of data in the sense that it harms consumers or is used anti-competitively, but also in certain circumstances can benefit consumers?
Mr. Chairman?
So I think it's very fact-specific. It depends on the circumstances, and you have to weigh one against the other.
Which gets into our problem is if you get to be so fact-specific that it's a little difficult for us to, we have to give you guys the tools. I agree with Mr. Neguse when he left, but also at the same time, at some point in time, we have to draw some kind of bright line laws. That's regardless of where you're at in any situation, at some point in time, we have to find some area where the regulation hits a certain point.
Well, our whole statute and the whole statutory regime is based on reasonableness. And so reasonableness means fact-dependent.
Well, you look at the effects and you look at the harms. I think that's what, in balancing that, at least for competition. That's not to say that should you come up with some kind of a regime that affects that. But we should be very careful because there's lots of consumer benefits, lots of efficiencies, lots of transactions. We just had our trilateral meeting in Ottawa just a few weeks ago, where the Canadian enforcement officials, the Mexican enforcement officials, Mr. Chairman and I, had the privilege of attending. And, to my surprise at least, the president of the Antitrust Authority in Mexico said she welcomed, for the first time, Amazon's entry into their market. They liked that because it lowered the price to the consumers because Walmart had such a big market share in Mexico. So I think we have to be careful about the possible positive effects some of these technologies could have. We have to just make sure that we're eliminating the harm that they'll create.
Well, and I agree with the reasonableness and fact specific, but also at some point in time, if there isn't some guiding, roadmap, then reasonableness is a great word because it sounds great, but reasonableness can vary significantly depending on who's hearing the case, and it's hard to continue to build a company or to start innovation if your sole basis is, well, we'll cross that bridge when we get there.
Yeah, so one of the things we've done in the past and we're going to do in the future is put out guidelines or commentaries that try to explain what are the things we look at and give the private bar and business community a better sense of what is over the line versus what is not over the line.
Thank you.
Thank you. The gentleman's time has expired. We recognize the